The Democratic Alliance says it has filed court papers to interdict the implementation of the 0.5 percentage point VAT increase contained in the 2025 budget. The budget was passed in Parliament on Wednesday after 194 members voted in favour of the fiscal framework, while 182 opposed it. The party believes that its case is strong. The adoption of the fiscal framework enables Parliament to proceed with the consideration of the remaining budget legislation. I'm joined now by Advocate Ben Cronin, who's a legal expert from UCT School of Law. A very good evening to you, Advocate Cronin. You just heard one political party there, the MK party, saying they're going to take this matter to the streets. The DA saying they're going to take it to the court and saying that Parliament processed the VAT budget was both, the way they did it was both unlawful and unconstitutional. What's your legal take on this?
Thank you. Yeah, no, so there are two parts to their court case. So the first is they're challenging the fiscal framework, which was adopted by Parliament on Wednesday. And what they're challenging on that side of their argument is the process that was followed by the committee to adopt the fiscal framework, because it has the option of either amending or accepting it. And I think what the papers put before court suggest is that the process followed by the committee was not procedurally correct, in that the key question, do you accept or wish to amend, was not actually adequately put to members of that joint committee hearing. The separate issue regarding VAT is actually, and this is a provision that I wrote my master's thesis on, it's a already existing provision in the VAT Act, and in fact the wording of this is similar to provisions in other tax acts, but it's a very unique power. It gives the Minister of Finance the power by mere announcement to change the VAT rate, which he did. And so on 1 May, the rate is set to increase, right, from 15 to 15.5%. Now, the question is, what can interrupt that? And really, there are only two avenues. One would be for Parliament to really rush through, which I struggle to believe is sort of feasible in the short time between now and 1 May, an amendment act. And the other route is what the Democratic Alliance, I think, is pursuing, which is to challenge the constitutionality of that provision. So it's doing both of these things. It's challenging the procedure leading up to the adoption of the fiscal framework, and it's challenging the power used by the minister to essentially just by announcement change the tax rate. And I think particularly in relation to the provision enabling the minister to change the VAT rate unilaterally, there are very important issues being put forward before the court, because if is, as seems to be the case, the majority of members of Parliament won't ultimately vote for the necessary ratification, the necessary change in the VAT rate by law, then if it's collected between 1 May and that future date and is retrospectively determined to be unlawful, then you have an enormous problem on your hands. So, it creates problems for Parliament, it creates problems for taxpayers who would almost certainly not get our refunds if it's unlawfully collected. But even more importantly, from my perspective, it creates huge problems for SARS. SARS officials will be caught in a catch-22 situation.
So does that mean then that this matter would be quite urgent to make sure that the case is finalized before May and before the VAT increases are then implemented?
Yes, so I think what the Democratic Alliance in its notice of motion is seeking from the court is a hearing before 1 May, precisely because it would like this matter to be heard urgently in order to, if at all possible, arrest the 1 May deadline being met. And as I say, there are multiple components to this motion. Included in it is not just challenging the provision, it's also challenging the decision taken by the minister to increase the VAT rate. But yes, in answer to your question, the timing is, especially given the 1 May deadline, very important.
One of the aspects that you've just explained to us as well, Advocate Cronin, was the procedural issue that the Democratic Alliance is also speaking of and heading to the courts as well. When it comes to the GNU, we are in uncharted territories in many, many ways. Now, with the budget having been passed for the first time by a GNU or a coalition kind of government at a national level, would the original procedure then still have to be put in place? Does the procedure not adapt now, considering that there is a different kind of political landscape now? So basically, how strong would the case be when it comes to the procedure and how things went about there?
Yeah, so I mean, one always is in the hands of court prejudging it would be perhaps too far. But in answer to your question, if the Democratic Alliance is successful on the first part, in other words, the issue regarding the fiscal framework, then what would happen is it would go back to the committee, to the joint committee, and effectively they'd be asked to do the process again, and then Parliament would have to consider it again. Underlying this is another unspoken of issue, which is the fiscal framework is not actually a lawmaking step. What it is a set of estimates and assumptions about the budget, which National Treasury presents through the Minister of Finance to Parliament. And I would argue that its true purpose should be about facilitating an amendment to money bills. In other words, to inform members of Parliament who can come from any background, might not be finance experts. It's to inform them of the basis for the budget and what they should understand are the sort of parameters that Treasury has used. But there's a pernicious provision in the Money Bills and Related Matters Act, which says that any subsequent money bills that are considered, so the division of revenue in 35 days, an appropriation, and indeed these tax acts, these are tax bills to amend the tax acts, they have to be considered, and any amendments to them need to be in accordance, according to the Money Bills Act, with the fiscal framework. So part of the battle here is reliance on a provision which I would also question the validity of. But the fiscal framework is not per se the budget. It is a set of assumptions underlying the budget. And we, I think, are treating it perhaps as more important than in the grand scheme of things it might in fact actually be, because none of the material decisions, actually the bills themselves, have not been presented to Parliament. And referring back to the VAT issue, that's exactly what's at stake here, is a decision has been taken, lawmaking decision, by a Minister of Finance without Parliament. And as you point out, right, the numbers are very close in the National Assembly. And I wonder if, given the apparent confusion about what was included in the fiscal framework, I'm not sure that it would pass. So a VAT rate increase, it's not clear to the average person like myself, right, that a majority in Parliament would vote for it. And that's why I think it's especially important that the court is considering this pernicious provision.
And with all that being said, just in closing, the DA says they have a strong case, they're confident in it. From your legal perspective, is it a strong case?
Look, I have a very particular view about the VAT provision that they are looking at. I wrote an opinion on this suggesting that it is unconstitutional. And I think the issues that are being raised, given the context that we are in now, certainly raise very important issues that the court hopefully will be able to address for us. I have no extra knowledge regarding the sort of occurrences that took place in the joint sitting of the finance committees. But I think the most important thing for all of us is that the court needs to solve, unfortunately, a riddle that has been presented by the way the law has been crafted. And it's going to need, I think, the court to resolve this enormously important issue, because VAT affects almost every sector of our society. And if it is unconstitutionally collected from 1 May, as I was saying a moment ago, it seems inconceivable that if people sought refunds, that it would be possible for all the millions of small transactions that this would affect.
It would cause quite a bit of an administrative nightmare. But speaking of,
Absolutely.
A backlog as well, just quickly, do you have a concern that the courts may get even busier with such cases as the GNU continues down a slippery pathway?
Yeah, well, it's always dangerous asking a lawyer if it's a good thing that there will be more court cases. But yes, I mean, I think it seems inevitable that there will be, as there's more friction, as new points of friction emerge within Parliament and parliamentary procedure, it seems inconceivable that there won't be more court cases arising from this. My view on the VAT provision is that this should have been challenged even under conditions different to ours now. So even before there was a hung parliament, I think that the constitutional issues raised there aren't just relevant to this context. They're relevant at all points in time. But as you say, and I joked with a colleague recently about this, there's a sort of inverse correlation between, if you're involved in social science research, if your field is doing well, often society is struggling in your field. And so I agree with you. I think this is probably one of many future court cases.
Well, Advocate Cronin, really appreciate your insights. Your colleagues and yourselves will clearly be quite busy. That was Advocate Ben Cronin.